Our student moderator has come.
Ritik hasn't come.
Our student moderator is there.
Sir, I'll call him. I'll just check with him.
Okay.
I think he is facing some network issues. So, Reti, can you take on the role of this student moderator also? And just ask student, please.
Okay, sure. No issues. Okay. Then we shall start, yeah? Okay, thank you. Good evening, all. Guest speaker, sir, good evening to you. Special good evening. Students, today we are here to learn on mediation advocacy. Our guest speaker is Dr. Hingorani, sir. So 1 minute, sir. My video is going off. Sorry again. Good evening, all. Our guest teacher speaker is Dr. Aman Hingorani. Let me tell you something about our speaker. Our speaker, Dr. Aman Hingorani, has uploads of credentials under his sleeves. He is a voracious reader and an avid writer. He has published many articles in various journals. His most acclaimed book, Unraveling the Kashmir Knot by Sage Publication, is one of the best sellers. Having a passion for ADR, he is an acclaimed arbitrator and a trained mediator, senior mediator rather, attached to the Supreme Court and Delhi High Court Mediation Center. Being an academician, to highlight a few of his works, he has prepared the materials for the All India Bar Examination conducted by the Bar Council of India, modules for advocacy skills, training for British Council New Delhi, ADR manual for the Federation of Indian Chamber of Commerce and Industry. He has to his credit of having trained many judges, students, and law faculties the art of mediation in India and abroad. His mediation practice started even before the court-annexed and institutional mediations came into existence. Sir, today we are very privileged to listen to you on mediation advocacy. Now the floor is yours.
Thank you for that, those kind words, and good evening to everyone. And of course, congratulations to the EMW for yet another hosting this particular classroom. I've been asked to speak on the role of an advocate pre, during, and post mediation. That is the role of a lawyer who is basically representing a party. So that is a slightly different slant or perspective which I intend sharing than an advocate who acts as a mediator. Now, but if we talk about the role of a lawyer as a negotiator or as a counsel for a party in mediation, that raises, in my view, the broader issue as to what is the role of a lawyer. Now, traditionally, what have we been doing? Before ADR really took off, before mediation really took off, at best you had arbitration, which was still adversarial. So a client would come to a lawyer and say, well, this is my problem. The lawyer would tell him, well, this is what you're entitled to in law. These are your rights or liabilities. Forget about what you want, but this is what you're going to get. And should you want me to litigate, you give instructions. I'll accordingly reduce your bundle of facts into rights and liabilities, fit it with the law, pigeonhole it with the law, file the case in court, let the court or the arbitrator decide. So that was, in many jurisdictions, the concept of what lawyering was. That was the role of the lawyer. The responsibility of the lawyer to give legal advice to his client, tell that client what he or she is entitled to in law, and try to get that particular relief from a court. When now that lawyers have to wear the hat of being a mediator or a negotiator, maybe even legal counselor, the very role of a lawyer is different. And so are the responsibilities of a lawyer. I'm told all of you have been through the basic elements of mediation. You would have gone through conflict resolution or breaking the conflict cycle. I assume you all know what a conflict cycle is. And would anybody like to share? I mean, I'd rather have this kind of an interactive session. Please feel free to unmute yourself, switch on your video and contribute, and just say whatever you want to say. So are you familiar with this term, conflict cycle? Anyone? Not?
It's an interactive session. Please, students, please unmute yourself and talk.
You can just unmute yourself and share your views on it. What is the conflict cycle in mediation? The whole idea of mediation is to transform conflict rather than decide conflict. So if you have heard the word conflict and you know how conflict can arise, in that context, you probably would have gone through the whole process of how a conflict can arise in society. So what is the cycle of conflict that a mediator is supposed to break to get the parties to come to some kind of a settlement? Anyone? No? Okay. So I think it will have to be a bit of spoon feeding. Well, to put it very simply, all of us have expectations, ambitions. We want to get something in life. And when we don't get that, we get frustrated. We start thinking as to why we're not getting what we want. And we sit down and we do a self-analysis. If I behave in this particular way, or if I act in this particular way, I'll probably get what I want. Now, if your analysis is correct, then you will get what you want. You succeed in getting what you want. But if your analysis is wrong, then you have modified your behavior. Your modified behavior would invite a reaction from the other side, who would then modify his or her behavior. And then you start a whole cycle of one party reacting to the behavior of the other party. So the role of a mediator essentially is to sit down with both the parties, understand where they're coming from, what was the self-analysis, where they've gone wrong, to be able to make them step back from the problem and then try to see if they see the problem in a different light. So that's the way a mediator breaks a conflict cycle. But for me, if you're talking about the role of a lawyer in a broader sense, this conflict cycle is equally important before you even decide to go into mediation, before the client even says they want mediation. This conflict cycle becomes relevant at the time of client interview. It is not important what you as a lawyer feel your client should get. What is important is what the client feels the client should get. It's the client's priorities, the client's interests, the client's wishes, or the way they prioritize their own interest. I might take less alimony, but I want the custody of the child. You can say as a lawyer, you're entitled to alimony. But the client says, to hell with the alimony. Let the other side guarantee they won't take away the custody. So it's not important what you feel as a lawyer you can get for the client. What is important is what the client wants their priorities addressed or satisfied. So the role of a lawyer, the minute you get a client, the client comes to you, tells this is what I am going through, this is what my problems are, these are the issues. You need to have very effective communication skills to gather information. You can't get into the self-analysis stage or break the conflict cycle or understand the conflict, how it arose, without getting information. So the crux of this is to get information. For that, I'm sure you would have discussed your communication skills, your client interviewing skills, how to listen to a client. People can listen to almost 4 times the number of words they speak. So listening is a very effective tool to gather information, to understand the information, to give the platform to the speaker, to the client, as to what is the uppermost issue in his or her mind. So the idea is to respect the client, let the client speak, give you information which you need to understand the client. And then I'm sure you have talked about passive listening, active listening. If you haven't, you can of course ask me. I intend having a question answer session, so you can always ask me these terms for those of you who are not familiar with it. But the basic communication is not a unilateral process. You say something, the other person, and you transmit it through a medium, the other person downloads that particular information, gives you a feedback. So that's a communication cycle. So you're communicating with the client. It's a two-way process where you're using skills of listening, active listening, passive listening, intent reflection, feeling reflection, so on and so forth. You're using your skills of questioning, leading questions or non-leading questions, focused non-leading questions. I assume you've done all this before. You use all these skills to gather information. You also use communication skills to get clues in a non-verbal manner. Verbal and non-verbal communication complement each other, but they can also contradict each other. To see the sincerity of a client, you have to see whether the client is saying something and the non-verbal behavior is something else. So there's a range of skills which are required of you as a lawyer to be able to gather information, to identify communication inhibitors. Again, I'm sure you're a study though. There are many inhibitors. Client may not tell you everything because the client may say, if I tell everything to the lawyer, he or she may think less of me, or this will weaken my case, or this is too painful for me to tell, or I don't even think it's important, I don't think it's relevant. So it's the responsibility of the lawyer to identify the communication inhibitor, overcome them. So the basic point is, your first responsibility of a lawyer is to gather information, full information, without slanting, without abstracting. Slant is basically when a client wants to give a particular perspective. Many of us want to understand things in the way we want to understand them. So there's already a slant in that information. Sometimes clients abstract. They tell only what they want to tell. So you need to get full information out of the client. And then there's a stage where you would give your opinion, you can give your advice, you can do legal counseling. All these are different terms. What's the difference between advice and legal counseling? Anybody? I'm sure you would have studied about what is legal counseling.
Sir, advice is not, it can be other than legal, legal legal advice is something that a lawyer give you. Advice can be given by anybody.
Then what is opinion?
Opinion, opinion is not, I think it's not it is something that doesn't have a legal sanctity attached with it. Opinion can be given by someone. Opinion, a doctor can give you opinion.
So can a legal advice or a medical advice have legal sanctity? That's the distinction.
But what a lawyer, being a lawyer in the capacity, in his official capacity, what he advises is a legal advice. But I don't think so. It's my knowledge that we cannot say legal advice that it's an opinion.
Okay. And how is all this different from legal counseling?
Legal counseling is something where a lawyer, counsels his clients that this is your this is your dispute, and then legally you can avail this opportunity, or this is your right.
Wouldn't that be advice then?
That can be advice as well. Yes, I am contradicting my own point.
Yeah.
Yes.
Well,
I would say that I'm not sure about it. Then what is legal counseling?
does a mediator in a private session, in a caucus, in a private session, does the mediator give advice, opinion, legal counseling on none of the above?
I think none of the above.
So, and you're right there. So that's the distinctions why we must have in mind as to what are these terms. Advice basically is when the lawyer gives a particular set of instructions and suggestions for the action to the client, that this is what you should be doing. So that is legal advice. That would also be medical advice if you want to draw parallels with the doctor. Opinion is the valuation of the lawyer on the merits of the case, the strength and weakness of the case. It's something similar to your reality check, your Vartna, where you're simply saying, well, these are the pros, these are the cons. So your assessment of the case is the opinion. And legal counseling is where you're addressing the client's broader interest, both legal, giving not only legal, but also non-legal options. Why don't you simply settle out of court? Why don't you write to the ministry for this relief? Where you're presenting with the client a full range of options. So the client is able to choose, should I really get into litigation? Or should I get into arbitration? Should I get into mediation? Should I get into negotiation? Should I just try a process which is none of these by talking to maybe some other authority or by going to the police? So each of these, I mean, of course, these are not watertight, compartmentalized distinctions, but each of these terms have a connotation. And the responsibility of a lawyer prior to getting into a mediation is to tell the client, is not only to give advice or the opinion, but also provide the whole range of options. If you go to court, this is what you're going to get. If you go to mediation, this is what you might get. So for a lawyer to be able to do this, the lawyer needs to basically get into the mind of the client. And that's where that whole idea of understanding how the conflict arose, where the client went wrong, what is it that basically the client wants, which is the best process which is suited to get what the client wants, not what the client is entitled to. There's a distinction between the two. And that becomes the responsibility of the lawyer before getting into mediation. If the lawyer and the client come to a consensus that maybe litigation is a better route, then you get into litigation. If they say ADR is a better route, then you get into ADR. So you'll see it's like a pyramid. The basis is communication. Superimposed on that is a case analysis, case strategy, getting into the adversarial mode. That's one direction. The other pyramid is communication, client interviewing skills at the base. On superimposed on that are negotiation skills, superimposed on them are mediation skills. That's a different direction. But the common denominator is communication. And so the role of a lawyer is not only to give an interview to the client and get the facts out of the client, it is to do much broader functions of being able to offer an entire range of options to the client that suit the client's need. And so that is the situation, coming back to where we started. Whatever we have talked about mediation, what you probably have read about mediation, that is relevant not only for the mediator of during the mediation process, that is equally relevant for the phases prior to a person deciding to get into mediation. Now, should a client say, I want to get into mediation, so you have to be my negotiator. What is the role of the lawyer then? Having explored litigation, arbitration, etc., and then come to a conclusion that if you're going in for mediation or a negotiation, the lawyer will have to have a very different mindset. Because the mindset in our adversarial system is to fight within the parameters of the law as per the rules of evidence, as per the rules of procedure. The mindset of a lawyer in a mediation is completely different. Because here the lawyer is not getting the conflict decided. The lawyer is getting the conflict transformed and by the parties themselves. Because what happens in the adversarial system, if you think about it, if you're getting into the adversarial system, if you're getting into litigation or arbitration, A has a problem with B, they've come to you as a lawyer. You will be speaking on behalf of that party. If you're A's lawyer, you'll be speaking on behalf of A. If you're B's lawyer, you'll be speaking on behalf of B. A and B don't talk. There's no communication channel. A and B are disempowered. A and B have no control over the fate of that case. It's the judge or the arbitrator who decides it. And so the litigation route requires the parties to be reduced into a bundle of rights. You abstract, you take away the socioeconomic context, you take away the reason why the conflict arose. You simply speak in terms of the statute or the case law. But the parties are disempowered. So the role of a lawyer is different. But the minute you come into mediation or negotiation, your role is to empower the parties. So the parties are able to take a decision or take control over their own dispute. You're supposed to take a back seat and let the parties vent out. Parties they need to let off the steam. They need to let off the trauma. They need to let go of the prejudices. They need to decondition so that they can then take a rational step into how to resolve their own conflict. So the role again becomes different. The skills of the lawyer becomes different. The skills of the lawyer is basically to give the parties, give the client a roadmap. What is the mediation process, a voluntary process, a party-centered process, a confidential process, a non-binding process where the parties themselves come to a negotiated binding settlement, which is facilitated by the third neutral party. The lawyer would need to tell the party, his client, about what is the status of that settlement agreement. Should there be a settlement? If it's a private mediation, that settlement agreement has the same status as the contract, can be specifically enforced. If it's a court-referred mediation, the court will dispose of the case in terms of the settlement agreement. It then becomes a decree of a court that can be enforced, and so on and so forth. All those distinctions will need to be given to the client so the client can make an informed decision. What is crucial is not only should the lawyer give advice, opinion, do counseling, or give all these instructions for mediation, it is the responsibility of a lawyer to ensure that the client is understood the implications of what the client is about to do. After that, the further responsibility of a role, or the further role of a lawyer, is to see whether this is the right time to negotiate. Where is the place of negotiation? It has to be neutral territory. The lawyer is supposed to sit with the client to search for the other side. What are the objectives of the other side? You just don't randomly go into a mediation. You need to do a preparation and information phase, as we call it, prior to mediation. You need to assess objectives of the side. You need to assess objectives of your client, the way somebody would go to the market and say, well, this is something I need to buy today. This is something I can live without for the time being. This is something, if it's not, the price is not right, I won't buy. So you make a shopping list. Similarly, the lawyer and the client have to make a shopping list. What is the outcome of that negotiation or mediation? What is it something that we must get, what we can live without, or something which we can give away, which we don't want? The lawyer and the client will do a reality check. What if negotiations fail? You probably have studied negotiation. You are familiar with the bargaining, with the whole terms of Bhatna, Vatna, Malatna. You're familiar with bargaining techniques, with the position-based bargaining, integrated bargaining, distributed bargaining, rights-based bargaining, and so on and so forth. You're familiar with negotiation techniques, as you pay to comply, salami, deadline, feigning, good guy, bad guy technique, limited authority. So there are many techniques which the lawyer and the client should be equipped with, but that particularly the lawyer has to have before getting into mediation. So all this has to be done prior to getting into mediation. This is the role of the lawyer, and the responsibility of the lawyer. You just can't land up in a mediation center before the mediator unprepared as to what you want to get out of that negotiation. Now, during mediation, of course, you need to take a back seat because you have to keep the ground rules of mediation in mind. It's a voluntary process. It's a party-centered process. You cannot take over. You cannot take over the flow. You can't in a way, become the voice of your client. Your client is the one who has to speak. Even where you feel the client is giving up more than what the client should give up, that's not your role. A negotiator, like a mediator, is not concerned with the fairness of the settlement. If the party is happy conceding something, it's a party's decision. Of course, you must keep in view that there's no power imbalance. If there's a power imbalance, your client is getting intimidated, your client is traumatized, client is not rational, then you would step in. But then you'll try to remove the power imbalance, but not otherwise. Otherwise, it's for the client to agree or to give up things, even if you feel the client need not give that up. Many mediators also use a technique to which is something similar to a role reversal. Suppose you're a lawyer for party A. The mediator can tell the party to leave the room and tell you as a lawyer party A to speak to party B so that you understand B's perspective. And B's lawyer may be asked to speak to your client in your absence. The purpose of doing this is to make the lawyers also see the perspective of the other side, so that they are more balanced when they're able to give suggestion to their own client, should the client want any suggestion. So the role of the mediator, a role of a negotiator in mediation is basically to let the party take a decision, not try to block the decision, not try to say, well, I'll get you a better deal in court, because no lawyer can guarantee results. And the better deal may not actually satisfy what the client is getting right now. Also, a common tendency is, should there be silence in a room? The lawyer starts speaking. That's the time when the party is deconditioning. That's the time when the party is thinking, should I give up this point? Should I concede, or should I insist on it? You need to show respect to your own client as a lawyer by keeping quiet, by staying silent. Let the party take the decision. That's a sense of mediation. Mediation is not lawyer driven. Mediation is party driven. Should the parties come to a settlement, then the role of a lawyer and the responsibility of a lawyer again becomes different. The settlement may give up a legal right, etc., but the settlement must still be within the parameters of the law. So you, as a lawyer representing a party in mediation, must ensure that no term of the settlement is contrary to the law, that the settlement is not about blame assessment, that neutral words are used, not non-judgmental language is used, the terms are clear, concise, complete, concrete, realistic, workable, because if it's a decree of a court, it has to be executed. So you can't have words saying A will pay B X amount of rupees as soon as possible. It means nothing. It will be A will pay B by demand draft within a period of 2 weeks from today. Nothing must be open-ended. Default clauses must be there. That's again something which a lawyer must ensure. What if a party backs out? The other side does not comply with their part of the deal. So you would ensure that the agreement is specific, is non-ambiguous. You don't use words like reasonable, soon, frequent, as soon as practicable, cooperative. Basically, you need to state who will do what, when, where, how, for how long, how much. And the skill of the lawyer is to demystify everything, use simple language, simple English, no legal jargon. It should be the language of the parties, because the parties must understand what they are signing. Because once they sign that agreement, they're bound by it. Once mediation is concluded, then you have a mediation settlement with you. If it's a private settlement agreement, it can be executed. It can be enforced as a contract. If it's a court next mediation and a court has disposed of the case in terms of the settlement agreement, then it is a decree. And then, of course, you would then get back into the legal route of enforcing that decree should the parties not agree to it. Should any party default or, for any reason try to delay or avoid doing what they were supposed to be doing. So if you see, broadly speaking, and of course, when should there be no settlement, the role of the lawyer is to again remind the party that the progress which has been made, what perhaps could be a possible term settlement in future. The lawyer must not misuse the mediation process to make it a discovery process. Let's go into mediation, let us see what the other side have against us. That would be unethical. That's not the purpose of mediation. But there's nothing called a failed mediation. There's still been some progress in mediation. And so the parties can be, the lawyer can congratulate the parties for at least given a best shot for mediation and for saying, well, we've come so far, maybe at a later stage, we're going to again try for mediation. Let's now go explore other alternatives. It is also possible, and that is something, again, the lawyer must keep in mind, is if in a given case, if there are multiple issues, it is possible to have partial settlement. So where the party is willing to concede on certain point or willing to settle on certain points, the lawyer can encourage the parties to settle on those points and to leave the other points for resolution either through court or arbitration or through some other means. So all these permutation combinations, etc., should also be is something which the lawyer should be able to facilitate and inform the parties. So this, broadly speaking, if you think about it now, right from just to sum up, because it's already 6:40 and I don't want to get into a question answer as opposed to having a kind of a lecture on it. We've already had about 40 minutes of lecture. Is that we start basically deconditioning the party, getting to the mind of the party, and that is a lot of psychology, and lawyers are not trained for that. Law students are not trained for that. Our law schools produces law graduates. They don't produce lawyers. They are no professional skills. The skills which you learn, moot courts. I've always said moot court is a good example how not to argue a case. You don't really argue matters like that in court. You need to unlearn once you get into once you join the practice. And the same problem is with mock trials, etc. None of these methods actually give you a immediate review of feedback or to improve your performance skills. Mediation, competitions, etc., are also are quite artificial. That has been my experience in the different law schools where I have been. So a lot of these skills you'll probably learn once you leave law school, or maybe you enroll for certain courses where you learn performance skills to be able to discharge your responsibility as a lawyer. But a lot of these skills involve psychology, a broader perspective of life, a broader perspective of what a client wants. It's not a question of getting brownie points or winning an argument in court. It's a question of getting the client to be at peace with that particular conflict. And so the role of the lawyer, right from the time the client comes to you, is not purely adversarial. It is a much broader role, as I've talked about, which would require to have excellent communication skills, client interviewing skills, counseling skills, negotiation skills, drafting skills, and of course, should you ever be a mediator, to have the mediation skills or the facilitative skills. And should you be getting into the adversarial mode, to have the lawyering skills, how to formulate case theories, how to be able to formulate, how to do witness handling, how to present your case. So, and these skills all complement each other. So that's the reason why that's a kind of overview which I wanted to give when we talk about mediation advocacy in context of a role of a lawyer pre, during, and post mediation. With that, I'll give back the floor to Revati. If somebody would like to ask questions, they want to have a discussion, you want me to expand on any particular aspect, you want me to repeat anything, please feel free to do so.
Thank you, sir. It was very enlightening. And this mediation advocacy is a subject which is very close to my heart. And I really enjoy listening to mediation advocacy and reading on it too. Students, now the floor is yours. You can ask questions.
Revati ji, our Ritik has joined.
All right.
Yes, he's also there.
Okay. So you could just unmute him and ask him to switch on his video.
Yes.
Okay.
Ritik, please unmute yourself.
Ritik?
Yes, ma'am.
Yeah. Yes, when there are certain questions, I think it will be in your chat box or something. You can just read through. think they'll be wondering they will, as a mediator, how they'll be talking to the client and acting as both as a mediator and client. It's Ritik? Ritik, are you there? So I
Well,
think
there's one question in the chat box whether leading questions being allowed during the process of mediation. Well, yes, let us. You see, the thing is that questioning is a tool of getting information. So normally what the kind of questions which we put are non-leading questions. Questions we start with who, what, where, why, how, could you please explain, could you please describe? So giving a platform to a person to say. And then of course you can focus those non-leading questions into giving reference of time or place or a circumstance or some incident, etc. But many times the party has a communication inhibitor. A party may feel embarrassed sharing a particular detail. A party may feel it may be inappropriate. It could be a question of propriety. A party might feel is too painful to recount this. So in that case, for a mediator in a private session, you would not do this in a joint session because you wouldn't want to embarrass that party in the presence of the other side. But should one of the roles, one of the purposes of having a private session is that should there be some information which the mediator feels is important for the mediator to understand the entire case, is to get into a private session, and there the mediator can ask a leading question. A leading question basically is a question which gives a statement of fact, you did this, didn't you? Or this happened, didn't it? So the party is supposed to simply say yes or no. So these questions can be asked. These questions are not meant to build rapport. They're not meant to give a party a platform. They're not meant to trigger off a line of thought, etc. It is basically meant to get a yes or no on a particular crucial detail which the mediator feels he or she needs. So to that extent, it is permissible to ask leading questions in mediation to get a confirmation or affirmative or a negation of a particular fact. But, and by the same token, it is permissible for a lawyer to ask leading questions from his or her client during client interviewing session. Because the lawyer must gather from information. One fact can change the entire complexion of the case. Facts are very crucial. And one fact can give a different spin on everything. And so if the lawyer feels he or she needs some particular information and the client is not forthcoming, client is not offering that information, or client is trying to actually avoid or trying to be evasive, then the lawyer can ask leading question or should ask leading question from his or her own client. So,
thank you,
any other question? Another question is, yes.
Yes, there is another question on the chat box, sir. Are counsels required for mediation as opposed to arbitration in which they are essential?
Well, no client would sign on the dotted line without the consent of the lawyer. And in my experience as a mediator, lawyers, if they're not part of the process, will more readily block the settlement agreement. They have different reasons. They may feel they get a better deal from the court. Many mediators put off lawyers. The minute you go in for mediation, the mediator tells the lawyer, well, this is only for the parties, why don't you leave? We'll call you if we need you. So you put the back of the lawyer, and the lawyer will be dismissive of the mediation process. The basic rule of mediation is every party who can block a settlement, every party who can facilitate a settlement should be part of mediation. unlike arbitration, unlike litigation, where it's only the aggrieved party. But in mediation, let the neighbor come in, let the friends come in, let the mother-in-law come in, let the sister-in-law come in. Whoever can block a settlement, whoever can facilitate a settlement should be part of the mediation process. So in my mediations, even though a lawyer need not necessarily is not legally required to be there, I welcome lawyers to be there. I tell the lawyers that I need their assistance. I tell lawyers that they need to be part of the process. Many times you can have uh, you can have a lawyer lean on his or her client if the client is being unreasonable. There are times where, like I pointed, a lawyer can be asked to speak to the other side's client and vice versa. Many times the parties are sent out and there's a private session. I, as a mediator, run a private session with only the lawyers of the side, of both sides, because the parties' mind may be clouded because of prejudice or because of trauma. The lawyers know exactly what will happen in court. So if you want to do a reality check, you can send the parties out and you can do a private session with lawyers of both sides. At times, there can be a situation where a party is taking a particular stand because of wrong advice given by a lawyer. And that lawyer may actually be thinking that he or she is right. So there's nothing to prevent a mediator from having a private session with a lawyer on one side. You can't do this in joint session. You can't in joint session tell lawyer you're legally wrong. The lawyer will walk off. So you can have a private session with that lawyer and in a nice way tell that lawyer, why don't you look up this law? So that that lawyer realizes the correct law and gives correct advice to the party who would then change the position. So lawyers, in my view, are critical for mediation. They may not be legally required for mediation, but they're critical for the mediation process. And wherever possible, the mediator must welcome the lawyer and make them part of the process. And also the fact that lawyers can charge heavily for sitting in mediation goes a long way in their being converted to mediation. Lawyers are opposing mediation because they felt that we lose our fees appearing in court if parties resolve their cases in mediation. But there's nothing to prevent a lawyer for charging for being in mediation. Court hearing may take 5 minutes, mediation sitting may take 1 hour. So a lawyer can actually charge more in mediation than he can charge in court. And the minute it becomes a source of income for lawyers, they would be more welcoming towards mediation. So the question is whether lawyers is essential, not legally, but if there is desirable that they should be made part of the mediation process.
Ritik, is there any other question? Could you just check the chat box?
There's a question about a free legal facility for the poor who can't afford an advocate. Well, yes, of course, you have the legal aid schemes under the Legal Service Authorities Act. You have the legal aid committees in the state, district level, state level, central level, even the Supreme Court. So you have those legal aid. Mediation, GenNxt mediation in most GenNxt mediation centers is normally free. And for pre-trial mediation also, it's only a nominal amount for the mediation process. And also, should somebody file a case and party be the matter be settled through mediation, the court fee is refunded. So mediation that way is an inexpensive process compared to litigation, and it is accessible to those who can't really afford a lawyer. So you can have a legal aid lawyer, or in mediation, the parties can come themselves. And then the mediator can facilitate the settlement by the parties themselves.
Any other questions here?
Hello, sir.
Yes.
Sir, I want to know if they, I mean, we have the Bar Council of India, which checks for the disciplinary actions. I mean, it acts as a disciplinary body. So, for mediation and arbitration, do we have anything like that? I mean, what if there's some disciplinary violation done by the mediators or the lawyers?
You see, you have in Salem Bar, and you have, again, you see all the judgments that you have rules of the ethical rules laid down for mediators. But you don't really have a standalone law on mediation yet. You don't have any system of accreditation of mediators. So basically what has happened in India is institutional mediation, where you would have every institution having their own rules. So should a mediator adopt an unethical practice, you can complain to that particular institution, and the mediator's name can be removed from the role of that particular, can be from the empanelment of that particular institution. Should it be a lawyer who is guilty of misconduct, whether in mediation, whether in arbitration, whether in litigation, the Bar Council always has a role to play, because Bar Council rules also require a lawyer to appear, to have a particular decorum and behave in a particular manner with particular standards of professional etiquettes, generally in society. It's not necessarily only within the courtroom. And so if you see, if a lawyer is resorting to virtual criminal activities in a mediation, then Bar Council, a complaint can be made to the Bar Council. So one is the Bar Council of India rules. Other are the ethical standards laid down for mediators and for conciliators. I have always argued that we don't need a standalone law for mediation. But basically, mediation, conciliation, as per the Law Commission, as per AFCON's judgment, even the Supreme Court has said mediation, conciliation are the same thing. Legislature just made artificial distinctions between mediation and conciliation, calling conciliation more proactive form of mediation. In real life, they are the same thing. We just need to have more clarity and a system of accreditation and disciplinary powers, etc., which can be brought by amendment into the Arbitration and Conciliation Act of '96, and that would serve its purpose. But as far as today we are concerned, there is no body to discipline mediators or conciliators, apart from the institutions and their powers also at best could be is to remove that person as a conciliator or a mediator impaneled with them. But that's about it. They can't really do much more than that.
Sir, I have a question.
Yeah, go ahead, Aman.
Yes, my question is related to the evidence. What is the role of evidence or witness in the process of mediation, or is there any role?
Of evidence? Well, no, not really. You see, a mediator is not a court. A mediator is not recording everything. There's confidentiality at several levels. Whatever is said in the mediation room cannot be used outside. Whatever is said in a private session, incidentally, rules in India are slightly different. Generally, all over the world, whatever is said in a private session cannot be communicated to the other side till the party says communicated. In India, the rule is the reverse. Whatever is said in a private session can be told to the other side, except what a party says keep confidential. But there's confidentiality attached to that. A mediator cannot disclose to the court as to what transpired in mediation. Only the court can say there's a settlement or a party came or did not come. A mediator cannot be a witness. Any proposal, any document exchanged during mediation cannot be used outside for evidence, cannot be cited against them. So there is actually no role of evidence in mediation, except where you want to do a reality check. When we talk about reality check, there are many models by which we can actually get parties to become more realistic. We in India don't train our mediators in that, but many jurisdictions, there is something called a pre-mediation dispute analysis, where parties walk through your Bhatna, etc., where parties are told what are your strongest points. Suppose party A is told, make a list of your strongest facts, make a list of your weakest facts, make a list of whatever evidence you have to substantiate your facts, make a list of your strongest arguments. Now think, so party A is asked to give you that, is asked to make that list. Then party A said, make this list from the perspective of B. Guess what is the strongest points for B? What is the weakest points for B? What is the evidence B has? What is the best case? What arguments of B? And then this lists are given in confidence to the mediator. But in the process, what has happened is a party is forced to reduce into writing what is the best evidence they have. And that's a reality check. Many times a party will say, well, my husband is earning 1 lakh rupees, I proved it in court, so I want maintenance of 50,000. But when the party is asked to show, well, what is his ITR returns? What is the evidence you have? Evidence will show he's earning only 10,000. So in court, you're not likely to get 50,000. So we use this pre-mediation dispute analysis models where we use evidence for the purpose of doing a reality check, that should there be no settlement, you get back to court, what is it that you want to get from court? So from that angle, yes, you can use evidence. You can also use evidence to basically dispel a perception, a wrong perception of one party. One party can say, I know as per his statement of accounts, he has these kind of assets. You can ask that party, do you mind sharing your statement of assets? Show your statement of your assets to the other side, which will disclose the true financial status. And the party discloses it, and the assets are far less than what the first party had assumed, then the party may become more realistic. Or if a party says, I agree I owe so much money, but I have no money, I have so many debts, and he says, I'm willing to show evidence of this, then the other side may become more flexible. So we use evidence from the point of view of getting parties to become more flexible, or to do a reality check, or to establish certain facts. To that extent, you can use evidence, but not otherwise. That evidence can't be used beyond that particular rule. Okay? Yeah.
Okay, thank you so much, sir. I have another question. A question was asked before about leading question. So during the mediation process, who can ask the leading question? I mean, during the mediation, the role of a lawyer is in the back front. Then who can ask the leading question during the process of mediation?
Mediator. The mediator will, if you see the job of a mediator is, if you go back to what we've been discussing, the complex cycle, a mediator cannot give legal advice, cannot give opinion, cannot do counseling. Because each one of them would take away from the neutrality of a mediator. A mediator has to be neutral, be even-handed with both sides. So without compromising on neutrality, the job of a mediator is to sit with either party, see where the self-analysis of the party went wrong, so as to be able to make the party step back from the problem. Now, in that process, when the mediator is gathering that information, if the party is giving information, well and good. But where a party is not giving information for a particular reason, the mediator can ask a leading question. But this will be in a private session, not a joint session. Similarly, if you have, and as you probably know, when you start with stage of mediation, you start with your opening statement, get the parties to share the perspective in a joint session. You shift gears, get into a private session, come back to joint sessions, come back to private sessions, go back to joint sessions. So you're shifting gears all the time, taking the parties through the different stages of mediation, of identifying the problems, identifying the issues, identifying the interests, getting them to shift to the underlying interest, putting the options on the table, evaluating options, building the momentum to a settlement. So all this is happening in joint and private sessions. So you, at any stage, you can ask, in a private session, you can ask a leading question, not only in the initial stage of breaking the conflict cycle, but at any stage of the mediation process. So it's a mediator who asks the leading questions, not the lawyers, not the negotiators.
Okay, thank you so much, sir. Thank you.
So there were some more confidential disclosure. Well, yes, there's a question about disclosure of confidential information. You have provisions made in the Conciliation Act which prohibit disclosure, which talk about confidentiality at different levels I've talked about. And you have similar provisions which are contained in Salimbar, the draft rules of mediation formulated by the Supreme Court, which have been framed then by the different high courts. So every high court has their own mediation rules, and they contain provisions which provide for confidentiality at the different levels at which I've spoken about.
So there's something on non-disclosure.
Yes. Is there non-disclosure clause mediation? Well, actually, non-disclosure, even the rules, for example, incidentally, and the law says that the terms of mediation need not be disclosed only except to the extent it's necessary for implementation of execution. So a party can say that we don't want to disclose this. We don't want, and this is important again, many times, the trade secrets. You're talking about commercial disputes. They can be IPR disputes. They can be, when you're talking about blockchain technology, smart contracts, people don't want to actually disclose many of their the IPRs. There could be matrimonial disputes. People don't want to disclose the amount of alimony or what arrangements they had. So they can say we want non-disclosure. But should a party default and the matter has that particular settlement agreement which has become a decree needs to be executed, then of course it will be disclosed in court. So to that extent, you can't prevent non-disclosure, but otherwise you can. And there's another question on arbitration. Arbitration is not voluntary. You see, most contracts now are multi-tiered. You would have that should there be a dispute, parties would go for negotiation, feeling that they would go in for mediation, feeling that they would go in for arbitration, and then of course you have litigation. So you exhaust each level. But once there is an arbitration clause, you can't, and the other side, and there's a dispute, then you need to go for arbitration. If the other side files a civil suit, then the defendant can object that in view of this arbitration clause, court has no jurisdiction, send the parties to arbitration. So it is not voluntary in that sense. Arbitration is a contractual term, so it's voluntary to that extent that you can include it as a contractual term. You can choose not to have arbitration in your contract. If you choose, you give a consent to arbitration, it is voluntary, it's by your choice of you're having arbitral clause. But once you have arbitral clause, then it's not voluntary. You have to go into arbitration. Unless you filed a case and the other side has waived it, or the other side does not raise objection in the first instance, and the civil court continues trying that case. So defendant has waived arbitration. That's a different situation. But otherwise, arbitration is certainly not voluntary.
So in fact, I have a very general question. You have been in practice for decades. What was that made you to mind shift that you moved to mediation, non-litigation side?
Well, actually, again, it's a question of the role which of a lawyer is something which I, right from day one, always felt that it's easier to be able to, I mean, or rather, if 90% of the cases are there because of ego or attitude issues or the wrong tone of a person. And if that can be addressed, we assume the worst about the other, but if that can be addressed, it's always better to reach out and see if we can settle it at that level. And then my initial interest in mediation practice started when I started teaching mediation in 1998 in Delhi University. So I was running the clinical legal education program, and the component of that program was not only advocacy skills, but also negotiation and mediation skills. And our universities, actually, the irony is that we teach practical training courses in a theoretical manner. So we give lectures on mediation, we give lectures on advocacy, and then we have mock trials or mock courses, etc., or show some videos. And according to me, all those are very old school teaching methods. The modern methods talk about, I mean, it's a philosophy that you absorb 30% of what you hear, you absorb about 60% of what you see people do, but you absorb 90% by doing it yourself. So when I started teaching in 98, since I was already practicing for several years as a lawyer, I introduced my own teaching method of learning by doing sessions. Making students perform on advocacy skill exercises, making students perform on mediation exercises, and giving a structured review on every performance. An area of concern, why is the area of concern, what's the remedy, how can you fix it, and then do an extempo demonstration to show how it can be fixed and get the students to do a review, a kind of a replay, and also do video review, record these performances on video, and issues like shuffling or waving of hands, lack of eye contact, those skills you learn, but you can teach through video review. Mm-hmm. So it's a very different teaching method. So I started my interest in mediation as a lawyer prior to teaching, but became a more structured way of teaching mediation and practicing mediation from 98 onwards when I started teaching in the Delhi University. And since then, it's been almost now 23 years teaching mediation.
Yeah, that's what they generally say. Communication is, words are just 7% and body language is, what do you call 70%. And the tone and all is 33%.
Yes.
So that is how, I mean, generally when you do talk to the client, we also tend to see the body language and see whether they are talking comfortably.
Yes. And it's very important. Body language is actually, actually you can, just the way two people are standing together, the proximity, the way the alignment, the eye contact, if a person is coming across as being very confident, but he or she is just pressing their fingers all the time, there's a contradiction. True. Many times in mediation, lawyers tell the party, just go and start crying there, in the particularly matrimonial cases. So you win the sympathy. So a mediator must test the sincerity of that emotion. And so body language becomes crucial. Even when you're doing a feeling reflection, that is basically you're reflecting back the emotion which a party is exhibiting. It's important to be able to identify not only the emotion, but also the intensity of that emotion. So if a person is really traumatized and they're in tears, they're not able to, their voice is broken down. So you can say, well, I can see you're extremely traumatized or you're upset. So that itself will build rapport. So to be able to relate in a non-verbal manner is crucial in mediation. So that's the way you would be able to get the party to get a sense of release, a good feel factor, that at least somebody is understanding what I'm going through. So these things are more important in mediation. Of course, in adversarial matters, we take away the emotions, the socio-economic context.
True. Any questions here? So I think there are no more questions now coming up, sir.
Sir, where can we get to hear about your training, sir? Get to know about your training? Would that be open for students?
Well, actually, I train in different universities, law schools. I'm invited to take a class for the students of that institution. So that's both for advocacy and for mediation. So unfortunately, I don't have my own training institute because I'm essentially a lawyer. But I do go to the different institutions across the country. So maybe if your particular university is having a particular training program and I'm there, then I'll be giving my training. And it is quite different. Of course, I do mediation training also at the Indian Law Institute. There's a postgraduate diploma program, which is in the evenings in the Indian Law Institute in New Delhi. So I do a bit of practical training, not the entire full course, but a slice of it. I train out there where students can get enrolled. But apart from that, I'm just training the final year students or the students who are doing clinical legal education in the respective universities. But it's a completely different concept of training. We don't. This is different from the trainings that are given by the high courts or the each high court has their own training centers and they run their training, the 40-hour programs, etc. This is completely different because the training is actually not lecture. It is only learning by doing sessions. And through learning by doing sessions, you learn the do's and don'ts of advocacy and also of mediation. So these are basically weekend programs, 2-day programs, 10 to 5, or a 3-day program at best for students. And for faculty training, it normally is a slightly longer program, which goes up to about 4 days to 5 days.
I think sir, I think there are no more questions now. I understand. Nothing is there in the chat box also.
Okay. Then we can end the session.
Sorry, I couldn't hear you, sir. You said something?
I'm saying so we can end the session now.
Yeah, I think no more questions. So it was a great, wonderful session. And as I told you earlier, this mediation advocacy is something which I really love the topic. So and I did have the opportunity to introduce you and listen to the subject thoroughly. Thank you, sir. And it is very interesting and very interactive. Students were quite interactive. Thanks a lot, sir.
All the best.
Thanks a lot, sir. Thanks a lot.
Thank you.
I think Revati we can end the session now.
Yeah, sure. Thank you.
Sir, with your permission, let me end the session now.
Thank you so much, Aman. Thank you. Thank you, Revati. Ritik, thank you so much. Thank you.
Okay.
Thank you, sir. Thank you so much.
Thank you, Harishna ji. How are
Thank you
you?
so much. Fine, sir. Thank you so much. Very nice class. We enjoyed it.
Yes, we really enjoyed it.
Really.
Okay. Then
Thank
with
you
your
so
permission,
much.
let me end the
Thank
session
you.
now.
Yes, sir.
Yes,
Thank you.
yes, sir.
Yes,